All right, court will hear now James E. Gardner Jr. against Lawrence v. Tilton, etc. Mr. Carlisle, you got all the cases this morning, or just the first two, huh?
I think that's the first two.
All right.
May it please the court, my name is Lauren Levy. I'm counsel for James Gardner, who's the Flagler County property appraiser. The 5 minutes for rebuttal, Your Honor, will be perfectly fine. Your Honor, this is a property tax case dealing with an agricultural classification, commonly referred to sometimes as the Greenbelt exemption. It's not really an exemption from property tax, rather it is a valuation solely tied to the agricultural activity being conducted on the property. Just to give you an example, the value of pine tree land may be different than the value of row crop land, but neither of those values would include any reversionary or speculative interest. It's just solely based on the agricultural use of the property. It's a preferred tax treatment, and the burden is that the plaintiff has to strictly show that they've complied with all the provisions.
The appellee suggests that the test here is whether there was substantial competent evidence to support the trial court's ruling. Are you agreeing or disagreeing with that assertion?
Your Honor, I would agree that in the vast majority of your reported agricultural classification cases, the appellate court repeatedly says these are fact cases to be resolved on a case-by-case basis. It's our belief that in this particular case, where we have the 06 decision and now we have the 07 case, that the court committed an error of law via the application of the statute to the facts, and we've tried to set them forth in the light most favorable to the appellant. And I intend to proceed under that burden, Your Honor, if I may. The facts, and I'll just start there, the facts in the light most favorable to Mr. Tilton were as he testified. That
I think I was on the panel the last time, and I think you and the opposing counsel took the opposite positions on that issue. In other words, they came in and said, hey, we got an agricultural exemption the year before, so we're good to go. They have to show that we stop use of agricultural use in all respects, and y'all came in and said, no, we just need to show some change, and if we show some change, then you go back to the substantial competent evidence test. Now, it just seems that y'all have reversed. Would that be a fair assertion?
Your Honor, certainly it would be a fair assertion, and in the first time, the initial thing that this court held in its opinion was there a proper application of the statute? And then they went on and said, now that we've decided that the statute was interpreted by the trial judge correctly, now we'll go to the next step of, is there competent substantial evidence to support his findings?
And the test was whether there had been a change, and we found there had been a change in the prior case, and in this case, the trial judge found at least two changes. One, the work on 23 parcels, and second, the fact that there were no units that had been sold or up for sale the prior year, or no parcels up for sale. So why wouldn't that constitute a change, which you then would go into the substantial competent evidence test?
I'll take each of those in order, Your Honor. First of all, for the 23 parcels, as we tried to make clear to the trial court, there is a possible resolution of the facts that would support agricultural classification for those 23 parcels only. They were chopped. That is an ag activity. It was the precursor to seeding that didn't occur until after January 1, which was our position. That's a future use. But there was activity on those 23 parcels in that geographically distinct area. So if you were to say, well, is there competent substantial evidence to support that's an ag activity on those 23 parcels, I would say yes, and if that were the case, those 23 parcels would be entitled to the agricultural classification. Your Honor, if you reject my argument that the second step for those 23 was to seed the parcels, just chopping them, preparing them to be seeded is not enough. You had to seed, and that occurred in February of 2008. So that's for the 23 parcels. That is a physical change from 06 to 07. That was the only physical change of this property. If I could move to the sales contract, Your Honor. The presence of the sales contract, the first time around when we had this case, we were talking about had there been a change. And Judge Watson had pointed out in his ruling the fact that these parcels had been under a contract for sale between August of 2005 and December 20th of 2005. And then he cited the statute that says there shall be a reclassification if the ag use has been discontinued. And that was the statute referenced in the material change part of the statute. That's all he said about it. When we got up on appeal, we were asked, well, why did we have this information about the sales contract? And we said, well, number one, it would reflect to the fact that there had been a change or allow an inference that the ag use had been discontinued, okay? Now, Your Honor, I want to distinguish that between is there an ag use of the property, but that the ag use had been discontinued. And then second, it was in response to the fact that during the first trial, they had considerable argument that we harvested 700 tons. We harvested 700 tons of trees. And we pointed to the sales contract and said, you didn't reserve the right to harvest timber, so therefore, Judge Watson, you could infer that just simply harvesting those trees was not bona fide, because that's not what bona fide tree farmers do, is place their property under a sales contract without a reservation of rights and then harvest timber. That was the only purpose of the sales contract, was change. It wasn't as relates to, is there a bona fide agricultural activity being conducted on January 1, 2007? That was the second part of this court's analysis the first time around. So the fact in 2007 that there's no sales contract pending doesn't change your determination of bona fide agricultural use. It's irrelevant to that determination. I cited one case in my brief, which is the Cassidy case, that says I have a citrus grove, it's bona fide citrus out there, I put a for sale sign on it. Do I lose my agricultural classification? The court said no. That's a speculative use. Maybe you're going to sell it in the future. The other case cited in my brief is the Genolio decision, which was a dairy farm that was placed under a contract for sale that spanned many years. But during that contract for sale, there was still an undisputed bona fide ag use. And the appellate court said, property appraiser, you can't rely on the fact that they're going to sell it in the future to deny your agricultural classification. So, Your Honor, whether there is a sales contract or not on January 1, 2007 is not a legally significant difference from 2006. My last point on that, if I could. The sales contract, the first time around, expired December 20th, 2005. So if we look at January 1, 2006, was there a sales contract in effect January 1, 2006? The answer is no. Did the sales contract come into whether there had been a material change from the prior value adjustment board decision? Yes, sir. But can it legally come into, is the property being used for a bona fide agricultural use? No, sir. And I argued that to the trial judge here. I said, if Judge Watson had said, I find that Mr. Tilton is using this property for a bona fide agricultural use, but for the sales contract, and I'm going to deny the ag on that basis, that would have been reversible error, Your Honor. It would have been. So we don't suggest that that's a material change from one year to the next. And we do suggest that the judge placed particular emphasis on that fact. They placed particular emphasis on it in the answer brief, Your Honor, and that is not, try to put it in a different way, that would not be competent substantial evidence to establish that fact.
In the last case, though, do you agree that the trial judge went beyond the fact that the property was for sale? He found that they could not cut down trees on property that was up for sale unless they had reserved it in the contract. And so it did go to use beyond just being up for sale. And that was a part of the trial judge's ruling in the last case, correct?
It was correct in that he said, well, you're suggesting that harvesting trees, you cut trees in 2005. You suggest that that is a bona fide agricultural use, and the judge said, no, that wasn't, because you didn't have a reservation of
The
rights.
fact that the parcels were up for sale, the trial judge found in the last case, and it was considered by, I assume, the trial judge in this case, went beyond just listing the property for sale. I mean, the trial judge found in the last case that it went toward use of the property, and that it tended to suggest it was not being used for agricultural use because he would not legally have been able to cut trees down from the parcels on which there was a contract for sale.
I would disagree in that respect, Your Honor.
That's what the trial judge found in the last case.
Current case.
No, in the last case.
And Judge Watson.
Right.
Now, Judge Watson cited the fact of the sales contract and then cited the statute that says the property appraiser shall reclassify if the agricultural use has been discontinued.
Right. but
That's all he said.
He found that as far as the use of the property, that there could not have been a legal removal, legal harvesting of trees on parcels for which there was a contract for sale. So it wasn't just that the land was up for sale. He also found that it went to use of the parcels. Now, in this case, there were no parcels up for sale, which also means there was no limitation by those sales contracts on being able to cut down trees on those particular parcels.
Let me try it this way, if I may, because I think we have a
No, would
disconnect.
you agree Judge Watson found what I just indicated?
Yes,
Okay.
Your Honor, because their argument in the first trial, we had said you're not doing anything agricultural related, first trial, okay? You're not doing any things that promote regrowth. And there was a dispute on that regard, fact dispute on that regard. They also argued, though, that we're certainly doing agriculture because we harvested 700 tons of trees. Judge Watson said, well, but you didn't have a reservation of rights, and so that kind of puts a little specter on that harvesting as far as it being bona fide. If we move 1 year forward to 2007, Your Honor, there's no harvesting between 06 and 07. The only fact that that sales contract was talked about was to deal with the harvesting issue. It did not go to, and could not legally go to, is the property, has it been used for a bona fide agricultural purpose? And that's why we think, Your Honor, that would be an error of law for the judge to say, well, there was a sales contract before, and now there's not a sales contract, and that makes a difference in the case. We don't think there's any case law that would support
Trees
that.
is not an agricultural purpose.
Harvesting
Trees for sale is not an agricultural purpose.
The testimony both times, both trials, Your Honor, harvesting trees for sale without active measures to promote regrowth or regeneration of your next crop is not a bona fide agricultural activity.
That's expert testimony?
Expert testimony. Yes, sir. And
It was uncontroverted.
that was uncontroverted. Both witnesses said that would be, both experts.
Agricultural activity is growing trees, then.
Correct. Growing.
Trees for harvest.
Correct. If it was row crops, I harvest my corn every year and I plant seed the next.
One day, right? I mean, it's on a particular day, right?
The courts have instructed us we must look at January 1st. We cannot look to future plans, which goes, if I may, which goes to the argument that we made in the brief, that we really felt that the judge relied on Mr. Tilton's plans for the future in looking at the ag use. He said he liked most favorable to Mr. Tilton now. Mr. Tilton said, well, once I got the denial in 06, I accelerated my management plan. First thing I did is I chopped these 23 parcels over here in October of 06.
Chop means
Mechanically chopping, preparing.
preparing them for seed.
Correct. That's the first thing I did. In February of 07, I hired a forester. I plowed 15 miles of fire lines. I prescribed burn part in late of
You
'07.
had to have the seed in the ground by January 1.
One of '08, which would be consistent with the Bystrom Union case that we cite in our brief, that merely preparing the ground would not be enough. Although, Your Honor, I would submit, if that were believed to be a factual dispute, that you had one expert said preparing the ground is enough, and another said, no, you got to have seed. That would only get you ag on those 23 parcels. That's 10%, or less than 10%. We had 266 parcels scattered about. We cut 23 over here in one corner. That has nothing to do with the agricultural status of the other property.
He said they were all in his plan, though, right? I mean, he said they were all part of his plan?
The rest?
The parcels?
Yes, sir. It was the rest of the parcels to do plans in the future.
Did your client take the position below that the 23 parcels should not be considered separately, but all the parcels should be viewed the same way, as one decision, if you would?
We argue that in two parts, Your Honor, both in the summary judgment, involuntary dismissal, and closing argument. We said, to begin with, everybody's trying to look at this property as a whole, because if we looked at it, each individual residential parcel, that couldn't be ag. But if you were to look at it piecemeal, the only ag would be for the 23 parcels. That's how we argue. And I see them.
So you're saying you argued in the alternative?
Yes, in the alternative is how we tried to argue that, Your Honor.
You want to say some rebuttal time?
I please do. Thank you very much.
4.5 minutes, sir.
May it please the court, I'm Chris Carlisle again for the appellees. Your Honor, Judge Evander, I think that your first question is the critical question in this case, and that is, what standard are we going to apply here? The law is beyond clear that it's a competent substantial evidence standard. Going back to the Greenwood case, the Florida Supreme Court said the appellate court is not to second-guess decisions of trial courts on these very factually intensive cases. The evidence in this case was provided by Mr. Sager, who was an expert who testified that in his expert opinion there was agricultural use going on January 1st of that year. There was evidence that the contract for sale and those things were not occurring during that time, which was a change. There was evidence that Mr. Tilton was observing the land and making decisions about what to cut, what not to cut, and did in fact spot cut a portion of the property. That's it. End of story. There was competent substantial evidence to support this verdict. That's it. We heard, again, something a little, I didn't really understand it, that somehow this is a question of law because the trial court misconstrued the statute. The only thing I've seen argued in the brief or heard argued today is that we disagree with the way the trial court applied it, therefore we get de novo review because they misconstrued the statute. The reality is the statute has those various factors for the trial court to consider when making that decision about the condition of the property on January 1st of that year. In this case, the court went through those, the expert went through those. There was evidence of each of the factors under the statute. The trial court heard it. The trial court took judicial notice of the previous year's, of the trial court for the previous year, that order, heard the expert testimony and reached its decision. How do they avoid that? Well, they avoid it by trying to say that, well, gosh, there was a previous decision of this court, and therefore that almost should have res judicata effect, thereby throwing out the entire system and the way this has worked in Florida, and the Supreme Court says it's to be worked. They agree it's a case-by-case basis. They agree it's factually dependent. They agree it happens on January 1st of every year. But now they're saying in this case, well, that's maybe not really true. We shouldn't really do that. That's the argument. And as I think as Judge Evander pointed out, we're hearing kind of both sides of talking out of both sides of the mouth in this case, not the least of which is that. They know that it's a competent substantial evidence standard. They know that there was evidence that met that standard below. They don't challenge it, but they're trying to say, well, you know, there's something, the sales contract, yeah, that was a feature of the trial that we put on, and this court found in the previous opinion that it was significant, but you know, that really doesn't matter. That really wasn't a big deal. It really wasn't a feature of that case. When it served their purposes to defend themselves and to defend their decision, they relied on it. Now we're hearing it really wasn't that big a deal. Was there competent substantial evidence? Undoubtedly. The point of the statute was, and the whole focus of the last case, and Judge Evander, as you pointed out, I know you're on the panel, there is a decision made by the property appraiser under the factors of 3B about whether or not there was a bona fide, good faith agricultural use on January 1st of that year. If a property owner is forced to go to a value adjustment board or forced to go to the trial court and wins, then there is a presumption that kicks in the future unless it's abandoned or discontinued. That's what the last case was about. That case does not matter as far as this case goes. It doesn't go both ways. The statute doesn't say if a property appraiser prevails at the trial court, then he has some sort of a presumption going forward. That's not in the statute, nor should it be in the statute. The statute was designed, as we were on another panel, Judge Evander, where Judge Berger talked about it, to prevent property appraisers from arbitrarily denying agricultural classifications when one has fought at a trial court or a value adjustment board to get that. So the point is, that statute does not apply to this case. A presumption that statute puts in place on behalf of a property owner does not, in order to the benefit of the property appraiser. The law is clear. January 1st of that year, was there evidence to support the trial court's decision? There was expert testimony. There was testimony from Mr. Tilton. There was no sales contract in place. There was chopping that went on. That's it. This case, again, is quite simple, and I think that the property appraiser likes the statute and likes the competent substantial evidence standard when they win. Obviously, they don't like it in this case when they lost. The issues are clear. There's nothing more to be said beyond the fact that there was evidence to support this ruling, and that's the end of this court's inquiry.
All right, thank you, sir.
Thank you very much.
A little over 4 minutes, sir.
And Your Honor, I'll be brief. 2006, that tax year was the beginning point. The court had found that ag use had been discontinued. And it's our position that as of 1/1/07, it was their burden, the taxpayer's burden, to show an actual physical use of this property had commenced. And what did they try to show? They showed chopping on 23 parcels over in one geographic area. For all the remaining parcels, their testimony was that Mr. Tilton monitored the property, rode around, and decided to do nothing. Riding around, deciding to do nothing is never going to be a basis to either allow you to receive ag or to turn down ag. The example I use, a developer riding around his property or her property deciding where they're going to put the Target store doesn't mean you lose ag. Likewise, riding around your property deciding that you don't need to do anything to obtain ag when the prior year you had been denied ag and the court had upheld that denial is insufficient. That's not actual physical use of the property, Your Honor, and that is simply a bedrock principle. So when we say the statute was misapplied, we're not trying to gussy up an argument on competent substantial evidence. We're saying we've got some bedrock principles here that require an actual physical use of the property on the land date.
What did the property owner's expert testify to?
The property appraiser's expert testified.
The owner's expert.
I'm sorry, the property owner's expert testified that he felt that Mr. Tilton was knowledgeable of his property and that riding around monitoring the property was an agricultural use, which is his testimony, but under our law, that would not be bona fide.
Did your client object to that testimony?
No.
Expert's opinion?
No, and the court said he really didn't resolve the case based on the expert's opinion. I'll give you an example, Your Honor. What if I had an expert come in and I want to go into the cattle farming business, and on January 1st, 2007, I've got plain pasture, but I want to save up my money, fence it, and buy some cows, and I have an expert come in and say, buying pasture with the idea of saving up money and buying cows is a bona fide ag use. Under our law, that would be insufficient. That could not constitute competent substantial evidence.
Inadmissible also. If an expert gives expert testimony that is contradicted by the law, the expert's testimony is inadmissible if it's objected to, right?
Your Honor, we've never looked at it that way. It would always be that evidence is simply not supportive of a conclusion that would lead you to an agricultural classification or not.
All right, sir.
Wouldn't Mr. Sager say that trees and cattle are different, and that you can do nothing when you're doing silviculture, just by riding around, checking on your trees. He called it active property management or something like that, didn't he?
Mr. Sager called it active property management, yes, Judge, and there is an old case that remarks that trees don't mature as fast as cows and chickens. There certainly is. But in this case, where we had a finding that in '06, that property is not being used for ag, riding around deciding not to change anything would not entitle you to the ag under the facts that we have here today.
Would riding around and monitoring your property be relevant or be supportive of a conclusion that the person was trying to use natural regeneration, if you would, and making sure that the conditions were such that you could do that, the natural regeneration would occur?
Sure, in a specific instance, it certainly could, Your Honor. I wouldn't disagree with that.
Right, but didn't Mr. Sager find that that was happening in this case?
He rode around, he said that Mr. Sager reached a determination that he believed a bona fide agricultural practice was occurring on the property. Yes, sir, Your Honor.
Using natural
regeneration
would
and
require the property owner to check out the conditions of the land and to see if they would support natural regeneration.
And if I may, I know my time's expired, if you were doing that in conjunction with the other things that would promote natural regeneration, you'd be there. But if you're doing that with nothing, then no.
But at least it would be relevant to a property owner using a method of natural regeneration, driving around the property.
In a different factual circumstance, yes, sir.
All right, sir, you're out of time. Thank you very much for your arguments.
Thank you.
All right, the court will